sit down.
No, it's the one appearing.
Okay, I'm working.
Are you doing it like that? Can you hold it
That's
like
okay.
that?
Alright. Good afternoon, everybody. Good afternoon, Muchineke. It is done and dusted. I said, let me use this opportunity to briefly update Biafrans on what happened in court today. Of course, the matter came up today for hearing of the main appeal before the Supreme Court. So, as you are aware, we have two appeals before the Supreme Court. Appeal number 1361, that is the main appeal filed by the federal government, and the appeal number 1394, that is the appeal we filed to challenge the order granted by the Court of Appeal staying in the execution of judgment of the court, same court, delivered on the 13th of October 2022. So, and however, today the both appeals came up for hearing, and first of all, the court had their main appeal, which is appeal number 1361, then which deals with appeal filed by the federal government challenging the judgment of the Court of Appeal. And of course, we are aware we cross appeal some part of judgment, segment of the judgment that has to do with status of IPOB. So that was what they referred to cross appeal, which we did in respect of the appeal. So today, the Chief Kanu Agabie also led us in the proceedings of today, and the advocacy and argument was delivered by Professor Michael Zekome, who has been leading us in the matter. So it was a very wonderful presentation before the court, and the entire argument was taken and briefs adopted, consequently adjourned to 15th of December 2023 for hearing. It's also important for judgment. So it's also important to emphasize, because to clarify, because before now we have two pending applications before the court, which is application for bail, and second one is application for transfer to prison. So, and you are aware the matter was coming up today for hearing of the main appeal. So the lead counsel and Silk was on the view, which is the correct position of the law, that they don't want to entertain any application that will delay the proceedings of today. Because if they had mentioned that any of the application, this appeal will not be had, and it will work gravely against the interests of Oyendo Mazen and Kanu. So they prefer to go with the main appeal, which is right for hearing, and which will take care of many issues we raised on those applications. So having been heard and adjourned for judgment, they apply for those applications to be withdrawn. So, and now the coast is clear. Also, the second appeal that has to do with our appeal against the other staying in the execution of judgment of the Court of Appeal was probably the court directed that it should be abide by the judgment of the court of this court, by somewhat consolidated. So the judgment on both will be delivered on December 15. So that's what simply happened in court today. And we thank God that, most importantly, the appeal was heard today, because we had issue with dates. Of course, we are aware that the matter was originally adjourned to 14th of September for hearing before it fall within the period of Supreme Court vacation. So it became an issue getting a fresh date. So which Professor Michael Zekome did everything humanly possible to ensure that this date is given to us. So, and I commend him and also commend the team who work assiduously to ensure that we give the best for Oyendo Mazen, Nnamdi Kanu in particular, and Biafrans in general. So today is a very wonderful day. The legal hostilities ended today in court, so awaiting judgment. So we have to go back and start praying. We have done our own part as lawyers. So also very important to observe that Chief Kanu Agabie saying that came in, commended the team led by Chief Michael Zekome, Professor Michael Zekome, for excellent work done so far, particularly the judgment of the Court of Appeal, which he said he read in between line, and they were excellent. So he commended us and also encouraged us thank us for the effort so far, and they also encourage us to continue But that's the most important thing. Of course, you are away, which I had constantly maintained that this is a sacrifice for our people. This is a way of contributing for the project. So, and anybody who's expecting money in return in this service is wasting his time. So, on my own part, I've done my part, and I shall always be there to render my legal services. So, within my professional ethics. So, and also to answer when I'm called upon, and also to assist. So, I encourage Biafrans and all over the world, particularly our people in the Southeast, to remain calm that we are approaching to the end of the game, because having taken this had this appeal today, nothing will happen to it again. Nobody can withdraw it again. So the law will take its course, and it's very difficult. I don't want to preempt the judgment of the Court of Appeal, but I believe that at the end of the tunnel, that there must be light, and something positive and good will happen. I believe so. I believe so, because I've done excellently and extremely well, and God will perfect the other ones remaining. So I commend everybody to remain calm and prayerful, and also to keep their eyes on the ball, most importantly. So people should not be derailed, should not be deceived by those who has other agenda from the project which Nnamdi Kanu started. So project of a peaceful agitation, which has had at all time carried on within the Conference of Laws. So the issue of IPOB status was also part of the appeal, which we form part of the issues we raised in our cross appeal, which I believe the Supreme Court will do justice to it on December 15, 2023. So it's part of issues we raised in this appeal, in our cross appeal. So I continue to urge us to maintain peace, remain focused, because a lot are happening. Of course, characters are coming out all over the places to probably to infiltrate and probably prevail on people not to understand the focus, the purpose of what they are doing. So I encourage them to remain focused and prayerful in the circumstance. We have between now and December 15 to get judgment, and I can assure you that justice will be served on this case. Will be served on this case come 15th of December 2023. Thank you so much for coming. My prayers for those that travel all the way from the east and all over the places to be part of this proceedings of today is that God will grant you all journeys back home, back to your several destinations. No harm will befall you, no accident of any nation. And for us who are also moving around, working day and night, God will continue to speak for grace. His grace shall continue to speak for us, and God shall continue to guide us and direct our path. So that's the most important thing. And I believe in justice, and we'll get it. Thank you, and God bless. And bless you for being part of this proceedings and for coming. Thank you.
Thank you, the pillar of justice. Master, thank you very much for work well done. All of us in the court, we saw everything by ourselves. Master, today court case has been fought very hard to make sure by your team to make sure this Mazi Nnamdi Kanu's case is sorted today. Master, what was your expectation and the date fixed for final judgment December 15? Are you okay with that?
The most important thing is that we have to, in Supreme Court, as a matter of fact, they don't usually give dates. They will tell you that they will reserve judgment for a day to be communicated to parties. So, but in this case, they were gracious enough to give us date. So I understand probably their dockets and schedule of work. So we have been exercising patience since June 29, 2021, and I believe we'll have less than 2 months of thereabout for the judgment. And the most important thing, let justice be served. And as has been rightly said by Lene Silk, Professor Michael Zekome, and Chief Kanu Agabi saying during the press briefing after the court session, we continue to call on the federal government to release Mazi Nnamdi Kanu unconditionally, because the fact remains that Nnamdi Kanu has been discharged. then of all indictments and criminal charges against him. That's number one. By virtue of judgment of the Court of Appeal delivered on October 13th, 2022. Listen to it carefully. Then the court proceeded in that judgment to restrain, to prohibit his further detention or further prosecution or any form of indictment before any court again. The court prohibited it and directed federal government to release him unconditionally. So, and to tell you the nature of this order, we appeal, subsequently, the same court of different panel sat and granted an order staying the execution of the judgment of the Court of Appeal. Same court. Then we appeal against it. We appeal against it in an appeal number SC 1394 pending before the Supreme Court today. I will tell you one funny thing that happened in this appeal. When we appeal it, when we file this appeal against that order, that unprecedented order, the federal government of Nigeria filed an application of plain objection challenging the competency of the appeal, and we responded. You will not believe that apart from that PLO they filed to that appeal, they did not file a responded brief in response to our appellate brief. They didn't file another process because there's no law availing the circumstance for them to rely upon. They have no law to rely upon in justifying the order, order which was granted without jurisdiction of the court. Are you with me? So that will tell you the nation how grave the order, how grave the order staying in execution of judgment of the Court of Appeal appears, because they have no law in head. It's an order granted under relying on civil proceedings, civil rules of the court, and civil precedent of the Supreme Court. There is no provisions under the extant criminal direction of the Court of Appeal that allows such an order to be granted, stay in the execution of liberty of a citizen. It hasn't happened. It's unprecedented. And to further demonstrate the seriousness of what they did, the federal government have no place to rely upon. They have no authority to rely upon in filing the respondent brief in that appeal today, and it was adopted today. So that will tell you the how serious or probably how unfounded in law that order is, right? So I thank God that they've taken everything. We are waiting the judgment of the Court of Appeal, the Supreme Court, which will be delivered on 15th. I urge us to remain calm. I know it's a matter of time, and I still join the leader of Professor Michael Zekome, Chief Gani Agabi saying, who called on federal government to immediately release on the Kano condition, because there's no justification for further detention. There's no justification whatsoever. If there's any justification for detaining him in breach or in violation of the judgment of Court of Appeal delivered on 13th of October 2022, they will have stated it in their respondent brief. They will file a challenge of appeal against that order. There's no justification whatsoever. So his detention today remains illegal, unconstitutional, and a gross violation of the stamp laws, and also by the order of the Court of Appeal, right? So we call on the government to do the needful by releasing him unconditionally and allowing him to go. Thank you.
Okay,
even before judgment is delivered on 15th of December, they have the liberty, they have the time to release him and ask him to go in compliance with the judgment of the Court of Appeal. Thank you.
Thank you, Pastor. Another question is this. I discovered that in the court, both parties did not argue over the date. Was it that it was predetermined, or because both parties just agreed? I was expecting Mike Ozekeme to argue to, reduce or bring back the date because of the condition of the.
This is Supreme Court. We even thank God that they mentioned date in Supreme Court. They don't give date, and once they mention date in Supreme Court, they have no authority whatsoever to challenge them, to even to prevail on them to change it. I believe you were in court when they adjourned the matter to 6th of February 2026.
Yes.
You are not there. It cannot matter. They adjourned it to 6th of February 2026. Are you not there? So you have no right or powers to challenge, to even utter a word once they fix the matter for judgment, because it's coming up for judgment, not hearing. It's only when it's coming up for hearing, they can probably appeal to them, my client is this and that and all whatnot. They will not consider it. And that was what they considered in giving us this date, 5th of October, for hearing this matter. Thank you.
Thank you very much. Another question, finally, Vice. Thank you very much. You know, Nigerian government like playing tricks. What happened if on the 15th of December they decided otherwise, maybe shifting the date?
No, it doesn't. It can't happen in Supreme Court. Thank you so much. It can't happen.
And another thing I want to ask, final question is there any way Nigeria can file any case again before that day?
No. We're done. It's done and dusted. You can't file. They cannot litigate upon the matter before the matter adjourned for judgment before the Supreme Court. They cannot file anything again.
And that is that if after the judgment, Nigerian government decide not to obey the judgment of the Supreme Court, what happened?
That means they're calling for war. I don't want to go. I don't want to get to that stage. I don't think so. They can't even dare. They can't even dare the authority of Supreme Court. Thank you.
Thank you very much, sir. And God bless you, sir.
And you too. Thank you for coming. Remain blessed. May Chukwu Kabiyama grant you journey mercy to your different destinations and remain careful, circumspect of a number of things. Thank you, and God bless.
Thank you, sir.
Okay, thank you.